Okay, welcome everybody. Welcome to the fourth webinar in our joint webinar series from 7 ongoing Horizon projects on irregular migration. People are entering still, but I propose we start. So my name is Ilse van Liemt and I'm the PI of iClaim, together with Nandos Sigona from the University of Birmingham. We coordinate this consortium of 16 partners, 6 academic partners and 10 civil society organizations. iClaim stands for Improving the Living and Labor Conditions of Irregularized Migrants and Their Households in Europe. And irregularized is a concept that we will hear more often during this webinar. It's actually one of the key concepts in our project. So it's important that I wanted to point out that we see irregular migration as a process in which migrants become irregular. So we don't see it as a static condition, but as something that is dynamic. It can change over time, and it's context dependent, and it's produced. So hence the title of this webinar, The Politics of Irregularity. We also have households in the title, which is also a very important concept in our project, because we're interested to not only look at the implications of what it's like being an irregular migrant or doing irregular work for an individual person, but we also are really interested to see what it means for the wider household, taking into account intersectional vulnerabilities as well. So today, we are going to present you the results of our first work package that focuses on policy and the legal frameworks around irregularity. So we have 6 countries that are part of our project: Finland, the Netherlands, Germany, UK, Italy. Did I forget one? Poland, sorry. And we've looked at the last 20 years of policy making in these countries, as well as at the EU level. So we want to understand how irregularity is produced and understood over time, and therefore we want to discuss with you the politics of irregularity today. And this first work packages in our consortium is coordinated by Lena Nare and Sabrina Marchetti from the University of Helsinki and the University of Venice. So they are the coordinators of this first work package, and they will present the findings of our first reports to you, so the key findings. And they are joined by postdoctoral researchers Paola Mirikoski and Letizia Palumbo. So I'm really looking forward to hear the first results from our first work package.
Thanks. Thank you, Ilse. So as Ilse already explained here, we present some, I would say, preliminary results as our final report isn't out yet, but nevertheless from our iClaim work package 3 on the production of irregularity through laws and policies in our partner countries as well as at the EU level. And we also look at some of the consequences of these policies for migrants and their families. We've collected the following datasets for this work package. We've conducted expert interviews with specialists in the field, 6 to 14 in each country. These include government officials from relevant ministries, state institutions, lawyers, specialists from NGOs, representatives of trade unions, cities, and municipalities. We've also collected and analyzed documentary data, legal text, policy reports, government programs, research-based reports. Next slide. So next slide, thanks. So how do we define irregularity in iClaim? Ilse already mentioned. I will just follow up on her discussion. We understand irregularity as a situation which is characterized by the lack of valid residence permit, right to remain or work in the country of residence, and or lack of recognized documentation. We also include in our approach to irregularity migrants whose residence status is precarious and/or temporary, so those who are at risk of falling into irregularity. So here we differ from official statistics, for instance. And this also means that irregularity can be a concern to intra-EU migrants who, for instance, have not been able to register the residence in countries where registration is required. Moreover, as Ilse also mentioned, we understand irregularity not as a quality of an individual or a group. It's a situation into which people end up through various routes, a situation produced by immigration, asylum, welfare and labor policies, legislations, and practices. Next slide. But we are also interested in the discursive construction of irregularity. We analyze how irregularity is also produced in state institutions, their daily practices and discourses, narratives, how these narratives are upheld in the media, in the political sphere, and through various societal narratives. And this is something we'll explore in more detail in work package 4. We argue that narratives matter, how irregularity is discursively constructed, how it is defined, who are understood as belonging to the category of irregular migrant relates to the management of irregularity, but it also has very concrete effects on individual lives. So in I Claim, the proposition is to approach irregularity as an assemblage, and this notion of irregularity assemblage seeks to grasp the different dimensions of the phenomenon, how irregularity is produced by laws, policies, practices, but also narratives, as well as, of course, broader labor market and welfare regimes and practices. And I now give the floor or the screen to Paula, who will continue on presenting the various paths into irregularity.
Thank you, Lena. So in our analysis, we've identified several paths how people end up in an irregular situation. So having one's asylum application or another kind of residence permit application rejected are common routes into irregularity. And so is also lacking recognized travel or identification documents. Then overstaying visa, meaning not leaving the country after visa expires, is also a route. So is expiry of other kind of residence permit and being unable to renew that permit. Then some people enter the country irregularly to begin with, and some people are also born in an irregular situation. So, for example, being born in an unrecognized state, or in an exile, for example, in refugee camps, or in many countries, being born to irregularized parents leads to the child being irregularized as well. And as Lena mentioned, EU citizens who have not registered their stay in another member state may end up in a situation that is comparable to irregularity. For example, vis-a-vis access to healthcare. And these paths are not mutually exclusive, and there might be other routes as well that we've not listed here, but all of these are common in the country context that we've studied. And it's also good to notice that irregularity is not always an either-or situation. So one may have a residence permit, but the work they do does not comply with the right to work regulations of that permit. Or people may not have a legal work contract. So people may work irregularly even if their stay in the country is regular, or vice versa. And what is the most prevalent route into irregularity also differs. So for example, in the UK, visa overstayers are the most common group. Interestingly, most of them are visit visas, not work or family or study-based. Whereas, for example, in Finland, rejected asylum seekers make up the largest group. Next slide, please. So in this work package, we've identified several legal and policy devices and practices, both on a national and on a regional level, that produce irregularized situations and affect people living in irregularized situations. We won't go through all possible policies here, but we've selected some that are occurring in all these countries that we've studied. So one key thing is that there are restrictive laws and policies for legal entry. So the closure of legal routes push people towards unauthorized routes that are also more dangerous. And the fact that there are increasingly strict requirements for all types of residence permits. For example, there are rules about where and how one can apply for a permit, which limits the possibilities for both authorized entry and regularization when in the country. And then also restrictions to changing one's permit from one category to another. For example, from an asylum applicant to a worker may be an obstacle for regularization. So for example, in Germany, changing from one permit category to another is not denied, but there are certain requirements and conditions that need to be met, and limited options into which permit type one may change their status. Moreover, the possibility of a change of category is in most cases a discretionary decision by the immigration authority rather than a legal entitlement, which makes it insecure. Also in Finland at the moment, the government is currently planning to make what they call lane changing impossible. That would mean that, for example, asylum seekers who find jobs will not be able to regularize despite of finding a job. And then in most of these countries, the law secures access only to minimal welfare services to irregularized people, such as urgent healthcare only. So, for example, in Netherlands, there is this linking act that has linked the connection, linked one's residence status and access to welfare and social rights since the 1990s. And this sort of linking is typical in all these countries to an extent. So in Netherlands, besides welfare services, this means exclusion in almost all aspects of social life that did not used to be dependent on one's migration status. So before this linking act, irregularized migrants were able to find some forms of inclusion, for example, through working. But now in linking act, the explicit goal is to prevent them from being able to integrate, because this could make them not wanting to leave or more difficult to deport. And it doesn't only affect the irregularized individual, but their household members also lose their access to social and health services, even if they have a status or citizenship. So this is a good example of a punitive kind of policy that seeks to make life difficult for irregularized people and also their families. And another such example is the hostile environment policy in the UK that refers to various everyday bordering practices. It requires universities and banks, landlords, employers, social workers, and so on to check the immigration status of their clients, and also for them to share data with the Home Office. This makes everyday life extremely precarious and access to services and basic rights very difficult to attain. Next slide, please. And migration laws and policies are intertwined with labor markets and labor laws, which produces particular precarities and vulnerabilities for migrant workers, among which are labor market testing that is done in most countries, which makes it quite difficult often for employers to employ third country nationals. And also it's difficult then for workers to gain employment-based residence permits. And because the residence permits are dependent on employment, that makes the workers highly dependent on employers, which often creates exploitative or otherwise unfair situations. For example, in Poland, there's a law that obliges employers to notify the labor office if they employ a foreigner within 2 weeks from the start of the employment. And if they do not, by no fault of their own, the worker falls into a situation where they are working basically in the grey economy. As a result, the worker may also lose their right to social assistance or even other rights related to residence in Poland. And the fact that these residence permits are often or almost always temporary or short-term, also creates bureaucratic traps for third country nationals. Next slide, please. And one major issue in producing irregularity is that the restrictive and inadequate asylum legislations and policies limit and undermine access to the right to asylum. So these policies and practices are politically driven, and they aim at controlling migration rather than making asylum processes reliable and just. And our analysis has also revealed, not yet, thanks. Our analysis has also revealed differential treatment within these policies and laws, or their practical that target certain racialized minorities and certain groups. So, for example, the Eastern European Roma are heavily marginalized, and they often lack access to basic services in most countries, regardless of having an EU citizenship. And then there are certain nationalities whose identification documents are not recognized in residence permit applications. So, for example, Somali and Afghan nationals may face this issue. And another form of differential treatment, and an example from the hostile environment policy in the UK is that while in the UK there are no uniform identity checks when people access public services, but the hostile environment policy kind of enhances racial profiling by encouraging checks on individuals who are perceived as foreign due to their skin color or accent or name. So this, of course, not only impacts irregularized migrants, but all racialized minorities. And while many of these policies are national, there are also regional differences in provision of welfare services, and certain cities or municipalities may choose to offer more than the national minimum. So, for example, some municipalities in Italy, such as Naples and Palermo, have challenged the national policy of restricting asylum seekers' access to civil registration, which affects persons' ability to access health services or, for example, opening a bank account. And also in Finland, the capital city Helsinki has for several years now offered wider health services to irregularized people than the minimum that is dictated by the law. But this also constitutes kind of de facto differential treatment based on the area of residence for the people. Next slide, please. So all these policies, they often create these what are called limbo situations, together with long bureaucratic processes, which are very typical. So for example, asylum seekers are often stuck in the process for several years, and they are living in an in-between state then. But not just asylum seekers, also other attempts to renew residence permits of other kinds may constitute a very long bureaucratic limbo. For example, in Italy, the processing times of new permits, as well as delays in renewals of older permits, are often very significant. So that means people are left without secured access to welfare services, for example, for months or even for years in an unclear situation. And then fear of loss of residence permit, not just for oneself, but often also for one's family, forces people to stay in exploitative or abusive employment, or perhaps in a violent relationships. And these can be perceived as kind of limbos as well. Furthermore, because there are in many residence permit types, there are restrictions to working legally, and then there are also unreasonably low basic welfare provision. So this turns individuals into easily exploitable labor force because they still need to work to make their ends meet. Also, those who don't have any right to work legally need to work to make their ends meet. And then rejected asylum seekers who cannot be deported because their country of origin does not receive deportees or because they lack travel documents are often stuck in a limbo with minimal rights and no real way to regularize. Tolerated status, such as Duldung in Germany, is also a limbo situation, because while tolerated individuals do have access to some basic services, such as basic healthcare and accommodation and food, there are at the same time several limitations to rights and living and working conditions, and also the obligation to leave the country remains in place. And next, our Italian team will continue on the routes out of irregularity and the challenges related to that. Thank you.
Thank you. Should I go? Okay. Good afternoon to everyone. In this second part, Sabrina Marchetti and I will focus on the pathways to regularization, highlighting the challenges and the requirement. And then we also focus on the relationships between irregular migration and irregular work based on the preliminary findings of the ICLAIM country reports. So with regard to the pathways to regularization, we can distinguish between large-scale regularization schemes and individualized regularization pathways. And as for large regularization schemes, some ICLAIM countries, like for instance the Netherlands and then in particular Italy, periodically resort to regularization schemes for undocumented migrant people already present in their territory. And in the case of the Netherlands, for instance, since 1998, there have been no employment-based regularizations, but regularization schemes have largely been due to governmental negligence, including, for instance, negligence concerning asylum application procedures. On the contrary, in Italy since 2002, regularization schemes have mainly concerned specific labor sectors. So there have been selective regularization plans applying to some specific labor market sectors, such as, for instance, the last regularization scheme adopted in 2020 applied only to care and domestic workers and agri-food workers. Then, if we look at the other ICLAIM countries, including Finland, Germany, the UK, and Poland, they have not adopted general regularization schemes for undocumented migrant people present in their territory. Next slide, please. So then, depending on the countries, we can see that there are specific and individualized regularization pathways. In particular, asylum is one of the main regularization channels, followed by migrant people. However, as already Paula mentioned, in many countries, including, for instance, Finland, and then in particular in Italy and the UK, recent restrictive asylum legislation and policies have significantly narrowed the access to international protection and humanitarian protection. And so this will probably, and has already result in an increase in the number of irregularized migrant people. And it's important to stress, and this is, for instance, particularly evident in the case of Italy, that these restrictive asylum policies have fostered and at the same time have been supported by the idea of economic migrants posed as asylum seekers abusing the national protection system. However, as mentioned in the quote from an Italian migration lawyer on the slide, actually the reality is not that the asylum mechanism is instrumentalized, but the core issue lies in the lack of channels for regular entry and a mechanism for regularization. And this denies migrant people the right to choose the legal migratory path they would like they would prefer to follow. Next slide, please. Another common route followed by irregularized migrants in order to regularize their status is applying for residence permits based on family ties and family relations. However, factors such as, for instance, bureaucratic procedures and strict requirements make it difficult in many ICLAIM countries to secure residence permit under this path. Moreover, in some countries, for instance, in Finland and Italy, regularization based on family ties have been recently subjected to severe restrictive reforms. Then another route in some European countries, such as, for instance, in Finland and in the Netherlands, is that a possibility for irregular migrant people already in their territory to apply for a residence permit based on employment. However, in both countries, in both in Finland and the Netherlands, requirements including, for instance, valid travel document, labor market testing, or salary requirements, all these requirements significantly limit the opportunities for obtaining this type of residence permit. Then in some countries, such as the UK, we have the possibility for a regularization pathway based on long-term settlement in the territory. For instance, in the case of the UK, we have the 20-year route to settlement on long residence. However, even in this case, the burden of proof required to demonstrate many years of continuous residence, that means 20 years of continuous residence, can be challenging, as many undocumented migrants may not have access to official documentation or records. Next slide, please. Other routes for regularization include residence permits for health-related issues or as victims of exploitation, trafficking, or gender violence. However, in many of the ICLAIM countries, strict requirements make these routes difficult to be followed. And in particular, in the case, for instance, of the victims of exploitation, trafficking, and gender violence, the fact that the issuing of the residence permits depends on the person's participation in criminal proceedings is an element that often prevents victims from following such regularization paths. And then we also have to consider that, of course, depending on the different countries, but in most of the ICLAIM countries, these types of residence permits are often temporary in nature, and in some cases, they do not allow a person to work and cannot be converted in another type of residence permit. Next slide, please. In general, next slide, please. In general, what we can say is that there is an increasing trend in many ICLAIM countries to provide temporary residence permits as a route for regularization, and this also applies in the case of people in situations of vulnerability. The fact that we have residence permits that are temporary in nature means that this significantly limits mobility between legal status and also opportunities for long-term social and labor inclusion. This trend, for instance, is very evident in Italy. And at the same time, the temporary nature of residence permit has significant impact. For instance, it creates stress and anxiety due to the constant, of course, concern and fear of becoming irregular, and at the same time it makes it difficult to plan for the future, and also in this, as a consequence, this amplifies and exacerbates already precarious living and working conditions. And as a consequence of this kind of impossibility to plan the future and the fear of becoming, or the constant fear of becoming irregular, has of course also negative consequence of the well-being and the legal status of the family members of the undocumented migrants. Next slide, please. So if we then consider a look at the EU level, what we can say is that the EU framework on legal and labor migration pays specific attention and mainly attention to third country nationals who are legally residing and wanted. within the EU. And actually, the framework, the EU legal framework on labor migration, does not provide any real answer and concrete solution for undocumented people who are already within the EU. And emblematic of this is, for instance, the case of the Seasonal Workers Directive that does not apply to undocumented seasonal migrant workers already in the EU territories, and therefore it cannot be used as an instrument for regularization. So from the EU approach and perspective, regularization process are seen as falling within the competencies of member states, and so that means that the EU cannot take action in this area. So now I will pass the floor to my colleague Sabrina Marchetti, who will focus on the issue of irregular migration and irregular work. Thanks for the attention.
Good evening. Thank you everyone for being here. So we know that while irregularity in migration status always corresponds to irregularity of employment and working conditions, the opposite is not necessarily true. This is in general valid in all our countries, ICLEM countries. As a consequence, migrant workers who do undeclared work are not necessarily also undocumented. They can indeed be regular residents, as it is the case for non-EU asylum seekers and intra-EU mobile citizens. This is in line with the definition by the European Labour Authority of undeclared work as any paid activities that are lawful as regards their nature, but not declared to public authorities, taking into account differences in the regulatory systems of the member states. So, undeclared or irregular work is not tied to the nationality or to the legal status of the workers. And here you have some lines from an interview we hold with the EU stakeholder. Next slide, please. In all our countries, the migration labor force has a very gendered and racialized characteristic. In an intersectional perspective, we see that their employment is also characterized simultaneously by legal stratifications on the basis of education, nationality, ethnicity, and so forth. This workforce is exposed to irregular and exploitative conditions in low-protected sectors such as domestic and care work, agriculture, and logistics. In all the ICLEM countries, both undocumented migrants and migrant workers in precarious conditions do experience undeclared and exploitative conditions. Especially workers of Roma origin occupy one of the lowest levels in the hierarchy of exploitation in most of the countries we analyzed. Next slide, please. Different forms and degrees of irregular and exploitative working conditions may lead to different situations of vulnerability, depending on the legal stratifications and the gendered and racialized regimes, as I said before, that are at play in each different country. However, in all the countries of ICLEM project, current laws and regulations have a negative impact on worker conditions, as in the case of regulations that apply to domestic workers, seasonal workers, and platform workers. Undeclared and exploitative work is often accepted by workers due to the lack of other concrete and better opportunities. The burden, especially for women, the burden of reproductive work and family responsibility plays a crucial role, as it often pushes migrant workers, especially women, as I said, to accept irregular and exploitative conditions in all countries. Yet, at the same time, it is also true that such irregular and exploitative working conditions also affect the well-being of the family members due to the inadequate living conditions, isolations, and marginalization. Next slide, please. Then, at the EU level, we see that in principle, the activities carried out by ELA cover only individuals who are subject to the union law within the scope of this regulation, including workers, self-employed persons, and job seekers, which means citizens of the union and third country nationals who are legally resident in the union, such as posted workers, intra-corporate transfers, and long-term residents. However, we want to emphasize that in practice, ELA activities also address EU citizens and third country nationals in situation of irregularity when it comes to tackle undeclared work. Concerning the Employers and Sanction Directive of 2009, we know that its primary aim is to combat irregular migration rather than to protect migrant workers. The repressive element against employers seems to prevail over the enforcement and effectiveness of the fundamental rights related elements with respect to the third country nationals who might be affected. Another limitation of this directive is also the fact that it applies only to undocumented third country nationals, leaving migrant workers with precarious legal status and who are victims of labor exploitation without protection. More recently, the EU Directive on Trafficking of 2011 has provided for a more human rights and gender-based approach. However, also this directive has limitations when it comes to its transposition and implementation, including on compensation and the actual enjoyment of rights by trafficking victims. Yes, yet so far, there have been no amendments to the protection, assistance, and the support provision, since the problem was considered as not due to the legislation itself, but rather to its implementation by the member states. And this has been seen, of course, as a missed opportunity by many. Next slide, please. So what are the next steps for our project? First of all, we want to analyze the dominant narratives and counter-narratives regarding the situation of irregular migrant people in Europe. We want to address, thanks to ethnographic research in particular, the effects of these policies on the living and working conditions of irregularized migrant workers in some key labor sectors. And finally, we want to identify relevant actions and practices to support the rights of irregularized migrant workers, including interventions by the side of institutions and civil society. Next slide. I don't know if...
I don't think that's...
The next appointment, yes.
Thank you very much. Thank you all for presenting, Lena, Paola, Letizia, and Sabrina. So thank you for offering first snapshots into the findings of our report. Maybe it's good to mention that these national reports will be published the end of April on our website, but there will also be a comparative report. So already during the presentation today, there were some hints made in terms of similarities and differences.